Good afternoon. My name is Alex, and I'm a partner at the law firm of Chase Lawyers, as you can see on your screen. And today we're going to be chatting about film, TV, and YouTube contracts, mostly as it relates to child actors as well as young digital creators. This is a topic that is quite relevant these days, where legal protection for child actors and dancers and influencers, as well as owners of family YouTube channels, has come to the forefront of folks' attentions, and rightfully so. A lot of parents focus on the exciting side of the opportunities, the additions, the sponsorships, the viral content, the TV appearances, the likes, the clicks, the ad revenue. But very few understand the contracts and the ownership issues, the labor rules, and as well as long-term financial consequences behind each single one of those decisions. So the goal of this presentation is relatively simple: to help parents and up-and-coming creators understand how to protect a young creator's future while still allowing them to build opportunities safely as well as strategically. To tell you a little bit about us, the firm has been around for over 3 decades. We are primarily focused in entertainment and music and film and TV as well as sports as far as our practice areas goes. We've also had quite a successful practice helping young digital creators of all ages and types of content from YouTube and Twitch and Kick and Instagram, influencers and creators to digital businesses and the like. So we have quite an understanding of both the entertainment and an online world, and would hope to join some of those experiences and be able to provide value to today. So without further ado, let's move on to our first slide. So the big thing here is the opportunity versus the risk. The entertainment and creator economy has never been more accessible, right? Everybody can do it. Everybody can do it from the phone that they have in their hand 24 hours a day. And today a child can build a pretty global audience from that said phone, appear in commercials, land brand sponsorships, and become part of TV shows or streaming productions. Quite a young age. We've had a number of clients who've achieved quite significant success, and are the proverbial provider for their families before ever reaching the age of majority. That of course creates that tremendous opportunity for income, for brand development, for long-term business value, as well as career opportunities, obviously. But at the same time, those same opportunities create legal risks. They're not just legal risks, but risks overall, financial, legal. But that is just what comes with success, right? So there's pretty much if you need an attorney, that probably means that you're doing something well to start off, unless you're being litigated against. But if you do need an attorney because the business is going so well that you now need to treat it as such, that's generally pretty positive sign there. And unfortunately, those legal risks often come in the form of contracts signed without proper review. The contracts may give away ownership rights, create exclusivity problems, expose children to privacy issues, or allow for perpetual or forever exploitation of your kid's image, name, image, and likeness, right? The NIL provisions and the NIL rights. Another issue here is that many people treat their business initially as social media fun rather than an actual business operation. This is the same advice we give to our young up-and-coming musician clients, and the same way we do with any digital creators that are now starting to make money, making it reasonable for them to put together legal structures and business structure and LLC structures, and have contracts with contractors, and make sure to properly take an assessment of your contracts, IP, your compliance with labor law, tax law, as well as general financial strategy that you have behind all of this new revenue that you're seeing or that your kid is seeing. So throughout this presentation, we're going to balance this focus on opportunity and at the same time making sure that we are preparing ourselves and preventing those risks and know about the risks that follow the opportunity that everybody out here is seeking in the entertainment space. Who actually owns the content? It's quite an important matter to discuss. And I am a little bit biased being an intellectual property attorney. However, this is one of the biggest misunderstandings in entertainment, as it turns out, and as you hear stories from musicians who've signed contracts early, or actors who are never new, or you hear sometimes sometimes you get a story of somebody being smart about their contractual negotiations and obtaining equity or a percentage from the movie's revenue, like Keanu Reeves in Matrix, or getting royalties from your music work, like the gentleman who performed Lion King song. So that is not necessarily always the case, right? The exceptions are there to underline the rule. And unfortunately, parents often assume that since since your child appeared in something, or since you hired somebody or paid somebody, then you must own the intellectual property associated with whatever the audio-visual product or audio product, visual product, whatever it is that your child has contributed to. That is not unfortunately true. Ownership doesn't follow dollars. Ownership follows paperwork. You need to be able to show that you have executed a properly drafted work for hire agreement or intellectual property assignment agreement that requires whoever you hired, the photographer, the videographer, whoever is doing any editing to the content, whoever is contributing to the creative ownership, creative product in any way, shape, or form. You need to have a specific express written language between yourselves and the contractor for you to own anything that they create, even if you have indeed paid for it. So that usually comes about oftentimes in TV and network productions, where the production company or studio generally owns the final content, right? In commercials, ownership depends heavily on the contract as well. How long can this content be used? Where can it be used? Is it just limited to this specific campaign, or does the brand now have an ability to use your kid's image everywhere and anywhere? Which platforms, which mediums? All of that creates additional need to assess whether you're giving up rights that you're being well paid for, right? Because at the end of the day, it's not about keeping close every single little right that you can. There is a time and place in a situation, in a scenario, where you can monetize those, but the idea is that you don't give up every single one of the rights to the full scope of perpetual, forever use throughout the universe to somebody if you then want to have them come back to you and pay you again, right? Or have somebody else pay you kid for the rights that you haven't granted to a specific single brand or client. Now in commercials, ownership defends, as mentioned on the contract. The music videos, that also creates additional layer because they involve the music rights, which can come in the form of sync rights and mechanical rights, performance rights, as well as image and likeness associated with people participating in the videos themselves. Now, when it comes to YouTube and digital content, this makes it specifically tricky because platform terms can also create pretty broad usage permission. For family created content or family channels, we always recommend structuring ownership properly from the beginning. And that applies obviously to any type of digital content creation, but the kind of rule is the moment you start considering digital content creation as a potential vehicle for actual professional development and business, you need to start treating it such, right? And in this instance, when it comes to digital content creation and creating content, posting it on YouTube, we strongly recommend protecting yourself through an LLC or a trust structure. That always helps establish who owns the channel, who owns the revenue, who controls licensing, as well as how the future deals are handled. The earlier this structure is created, the cleaner and more valuable the business becomes later. Commercials. The money is in the usage. Yeah, it's one of the good ones. This is one of the most important concepts in entertainment here, right? The real money is not necessarily earned on the filming day. The money is earned in the usage rights, which means the post-shooting use and continued use and reshoots and reposts. The idea here is that a session fee pays for the time spent filming, and the usage fee pays for how the company exploits the content after the fact. And those are very, very different things. One gets you paid once, the other one has the potential to pay you in perpetuity, meaning forever. For example, a child may receive a pretty modest payment for filming a toy commercial, right? And it's gonna have that work for hire element to it as well. If the audiovisual company or the advertising company hiring you has their stuff properly set up. And if the commercial runs nationally on TV or YouTube, TikTok, paid ads, streaming platforms, the overall value of that commercial and its the value to the brand and how much money it makes for the brand becomes much larger, logically leading to a pretty reasonable request, if you have the necessary leverage, if you even know that you can ask for it, to request usage rights in addition to just the filming rights, the session fee, right? Parents need to pay quite a lot of attention to the territory to which their kids' name, image, and likeness, or to which the rights to the content being created by them or licensed by them to a third party. They need to pay attention to the territory, to the duration of the term. Is it forever? Does it have a termination? Does it have a post-term obligation? Platforms, the mediums through which the specific content can be distributed, something that your kid participated in can be distributed on TikTok, or whether it's YouTube, or whether it's film, TV. As well as renewal rights. Is there an ability for them to call you back for an additional shoot? Is there an ability for you to get paid for it? Is there any restrictions on you as far as exclusivity goes? That's a big one. As the broad exclusivity clause can, pretty significantly block your future opportunities with competing brands if you allow yourself an early exclusivity that wasn't properly compensated for, once again, right? If we're not expecting an exclusivity to come as a result of a single engagement, right, logically, now, if that is the scope of your, and in this instance, the brand's potential interest in a client, then the idea is to ensure that they don't get the full scope of everything that that client can then go and sell to somebody else. So the key lesson is the contract is not just about getting paid today. It's about controlling future limitations and future value, ensuring that you maximize your kids' earning opportunities in the long term. A little bit about music videos and appearances, right? Appearances as far as audiovisual content goes. They can create quite unique legal issues because they often combine entertainment and social media and advertising and promotional content. All of those different executions have different layers to them. Parents should pay pretty close attention to anything relating to appearance releases, editing approvals, international usage rights, and generally monetization rights. A lot of people overlook things like ancillary usage rights, which is usually at the bottom of those contracts, which would be potentially applicable to behind the scenes footage, right? The BTS, any TikTok edits, outdoor visuals, YouTube monetization, promotional snippets. There's a lot of different highlights. Sometimes the original appearance payment only covers the initial shoot, what we just talked about on another slide, and not at all any downstream exploitation, which is something that you as a parent need to ensure that you've at least brought up with the counterparty, right? You're not always off the bat going to get the full scope of filming and usage and ancillary rights and limited rights and just limited to the territory, and you're not always going to have that leverage, and that's okay. But the question is, do you know the full scope of, here are the 12 things that if I had the full scope of leverage, I would be able to request pretty comfortably from this specific brand or client. If you can't say that, if you don't have that knowledge, then you're kind of facing with a little bit of a Socratic question here. You don't know what you don't know, right? So you want to ensure that you have that education up front. This is exactly why I'm assuming you are here listening to myself chat about these topics. But you want to ensure that you give your kid as much of an advantage, and this is kind of exactly what we're doing here. You need to ensure that you exercise that advantage, or you ask for things, because nobody's ever been beaten up for asking, or at least that's a saying that we have background from. But at the end of the day, you want to be able to request benefits, and if they are not able to provide those to you, well, it is what it is. But I think it's very important to know what are some of those things that you could potentially request from a counterparty. And this is also coming back, and we'll talk about it later, but having a good team around you, whether of agents, managers, advisors, attorneys, people who've been in these conversations, people who have executed these deals, people who can provide industry knowledge in addition to the specific hard skill value that they provide. And understandably, to sum this slide up, once the footage exists online, once your kid was filmed somewhere, it can be reused in ways that you never anticipate. And that's what a lot of our model clients come to us for. That would be removing content of brands using their image for campaigns that they were never ever paid for, right? That's often the case, unfortunately, in the modeling and fashion space. And that is why clarity in drafting contracts and knowing what is included in the contracts that you sign is so important. Coming back to the family YouTube channels and owning media. And owning here is a very important principle, right? The family channels these days have evolved from hobby projects into real businesses. We have a number of clients who are obtaining financing on the basis of their YouTube revenue as collateral to provide for additional cushion for them to invest into the business and the development and the marketing, as well as a number of clients who are in the process of selling their channels, right? Usually there's some transitionary period, especially when the ownership of a channel gets changed. There's still a need for the creator to continue creating either way, right? In order to ensure that they stay at the front of the channel. So a lot of these have turned from your hobby, your social media, your funds, family activity into businesses that generate sponsorship revenue, merchandise income, licensing opportunity, and if businesses doing well enough, and acquisition value as well. Which means that parents generally should stop treating their channel like a casual personal account, right? If you are in that space of how do I make content into business. Instead, think of it as a media company. Who owns the channel? Is there a legal entity behind it? Is there proper contracts with people contributing to the content being shown and monetized on the channel? Is there registration when it comes to intellectual property, whether copyrights in the content itself or trademarks in the logos, brand names, slogans, and any other insignia, any other symbols that customers recognize you by, right? The name of your channel, your logo, and the like. And of course, it's important to know who controls monetization, how is revenue documented. The more, the the better you can document your revenue sources, the better you can structures you can put in place to optimize it, to minimize taxation, to optimize revenue flows, the more likely you are to be in that acquisition scenario at some point. And as far as our general recommendations to folks starting out, their YouTube content channels, you want to have a parent-owned LLC. You want to have proper accounting and payroll software systems implemented, QuickBooks and the ADPs of the world. You want to have written arrangements for any splits of revenue or management of the company, whether it be between the two parents, as well as providing for what happens if the marriage of the parents doesn't go as planned. Is there a specific system via which, is there a specific structure via which the business is to be inherited by the child? Is there a specific person that's going to be managing the systems? Is there a specific individual who is going to be the key person for the entity? All of that is very, very important to identify at the forefront. Why? It's because if the channel grows substantially, the investors, buyers, or partners will eventually be asking who legally owns it. Right? And if you want to bring in any third-party capital, you will probably have to answer some of those questions. And if it's unclear, it creates a lot of major problems later. Child labor. So here there's a significant, substantial portion of this goes back to the days of early 20th century Hollywood, and a number of instances, unfortunately, on the West Coast in Hollywood of child actors reaching their 18 years old and suddenly realizing that they didn't have any money because their parents spent it all on lavish lifestyles. Many parents do not realize that entertainment productions that involve minors are pretty heavily regulated. That's what we're trying to sum up here. Those rules vary by state, but they generally include work permits, specific hour limitations, educational requirements. How long can a child participate in the shooting outside, and how many hours does the program need to involve school hours for, right? As well as compliance with those obligations for production companies that can be found to be in violation. Cali and New York are particularly strict. Cali has some of the strongest child performer protections in the country. And those rules exist for a reason, right? We want to prevent exploitation. We want to protect the education and well-being of children. And the violations can, be pretty significant and sometimes expose both parents and productions to serious legal liability. And just because something is for YouTube does not automatically remove labor law concerns. All digital content is considered to be audiovisual production, especially if it is commercialized. And the more it is so, the more attention will the regulators pay to monetize child content. You've seen this more and more in a lot of different jurisdictions across the US. There is a variety of different laws in different states that specifically deals with digital content creators and content video bloggers that have more than a specific percentage of content, involving their children, need to specifically reserve portion of the income and allocate that into a specific fund, which is the new world, the 2025-2026 version of Coogan Law, which is that original law back in the beginning of the 20th century when it comes to child labor laws, specifically when it comes to Hollywood and at that point movies. Coogan Law is one of the most important legal protections for child performers, and those variety of different state laws dedicated to children of video bloggers or content involving children was created often in mirroring and trying to kind of make sure that the content is similar to that of Coogan Law. Coogan Law was created after child actor Jackie Coogan, who earned substantial amount of fame and income as a minor, being a child actor, but later discovered that his parents spent it all. Today, California requires a portion of said child performer's earnings to be placed into a blocked trust account, which is supposed to protect the money until the child becomes an adult. The percentage varies depending on the circumstances. It's 15%, and a lot of the new legislation associated with digital content creators and child content there similarly follows that 15% denomination. But the principle is pretty simple. The child's earnings should belong to the child. And most importantly, this can apply even if the child is even not a California resident, or if the work is tied to California entertainment activity, which, a lot of work is. And ignoring Coogan requirements or similarly drafted state laws mirroring Coogan Law when it comes to digital content creation can create substantial financial penalties, contract issues, both for brands and parents, as well as legal exposure. So this is not necessarily optional. It's a pretty critical protection mechanism, so make sure to get yourselves familiar, especially if you have your kid collaborate with somebody and then you or your LLC, your audiovisual company, acts as a employer or a party contracting with another child that is to collaborate with your kid, that potentially can bring some additional requirements for compliance on you as a production entity as well. What are some of these missteps that we try to prevent our clients from committing whenever we advise them in their digital content creation or in supporting their kids' digital content creation careers? Most financial problems in the industry are not caused by fraud per se. They're caused by lack of structure, or lack of processes, or lack of proper business structures and informality. Unfortunately, parents often deposit funds into personal accounts, use Cash Apps and Venmos and PayPals and all the different Zells of the world to perform payments on behalf of their kids without any proper tracking or bookkeeping, as well as failing to track specific revenue, failing to record things, failing to pay taxes is a big and bad one, or failure to ever establish proper ownership structures, as we've discussed. That creates a lot of tax problems, accounting problems, ownership disputes, other legal risks. Another major issue is failing to create a trust or that loan out company structure. Without proper legal entity filed with the Secretary of State in the specific state where you live, and without proper documentation, it becomes unclear or can be subject to interpretation, which means subject to a dispute, which means costs a lot of money in court. Without proper documentation, you don't really know whose money it is, who owns the IP, or how the income should be reported. And the more successful your kid becomes, the bigger those problems become later. Because a good structure, if done properly and if done early, prevents expensive cleanup later. Because whether in movies or in music or in YouTube streaming, you never want to be chasing collaborators for compliance slips. You never want to be running after producers to get that license after you've stolen a bit from them from YouTube or whatnot, right? You want to ensure that you get paperwork before money ever exchanges hands. You want to ensure you get paperwork before the content is created, so that when it is created, the splits of ownership and any type of assignment or payment rules are properly identified in the relevant paperwork. LLCs, right? This is another big one that we've touched upon. And setting up your kid with an LLC or a loan out company structure, and the LLC is a specific type of a legal entity, while the loan out is the actual function that it performs, allows you and your kid to avoid additional liability due to the limited liability structure of a limited liability company, which is the what the LLC stands for. You allow your child to have protection from any creditor's claims to the extent that it doesn't concern the fund specifically on the LLC's bank accounts. You protect any and all property interests or any other businesses from one another and from the creditors or claimants who have any issues with one of your businesses or with any of your contracts. Pretty much the more separation you have, the harder it is to get to the whole pie, right? If we're looking at it as, as a pie chart, if your LLC represents a thin slice of it, that means that the rest of the pie, representing your assets and your home and your apartments and your cars and whatever else, will not be affected if you maintain that separation of personal and legal entity, business, accounts, monies, and if you don't, if you commingle, the personal finances, the activities, if you have things not be properly structured and not realize that things need to go to a business bank account when it is associated with a business payment into a personal bank account through a payroll software from the business to establish an efficient operating system of optimized taxation, then you risk potentially having your corporate veil be pierced. And that's the specific legal lingo, but what it means is that if there's any showing of fraud, if there's any showing of somebody using the company as a shell, meaning just using it in order to obtain that protection, but actually not treating it as a separate business, just treating it as a separate bank account pretty much, then that creates an ability for anybody suing you to get to your actual funds, to get to your property, to get to your other businesses, to get to your personal belongings and potentially claim against those. Now, LLCs would have an operating agreement. A trust would have its own rules set up by your estate or wills attorney. And in any way, shape, or form, a trust is used to ensure similarly that the assets are protected, especially if you want to have a specific formats of their trust funds distribution to your kid after they reach 18, or maybe after they reach 25 or 30. Different, folks prefer different structures in there, but all of those work if you're working with a business or trust attorney and are being thoughtful about the process of establishing those structures. You need to also establish payroll softwares, right? We mentioned it before. Ensure that you file your 1099s and collect all the necessary tax documents before you file with the IRS. Make sure to get a bookkeeper. Make sure to get an accountant. It doesn't cost that much, especially if you're having any form of success comparatively so, right? And you want somebody competent, cooperating with the IRS on your behalf if you want to ensure that your business is properly structured and continues to operate successfully. With that, entertainment businesses are quite often audited because income streams can be fragmented, across sponsorships and YouTube revenue and Twitch revenue and licensing and affiliate income, right, and appearances. So having good documentation protects everybody in case of such an audit. So here we've come to the topic of your team, right? Your agency, your managers, your producers, anybody and everybody that is being hired by you and your kid, right? Because at the end of the day, remember that those are service providers that you are paying, meaning they need to explain to you the specific services that they're going to be performing for you, and you need to ensure that they don't try to get their hands on the compensation that is potentially reserved for another one of those functions, right? Things that the booking agent will do for you are different than what a manager will do for you. It can be different from what a producer can do for you. Now, there could be an instance where a manager can do all of those things, right? Or an agent or producer, whatever the case, but you want to ensure that you as a parent know yourself or have an attorney that does this, that can recommend you what is customarily included in these agreements, because the compensation that somebody responsible for getting you booking and performance gigs is going to be different from somebody who just generally performs business management functionality associated with any and all revenue sources of yours, and is going to be different with somebody who is involved with you and your kid on the producer single project basis. Those are going to be different types of relationships that will not always require the full scope of, percentages, attributions, commissions, or whatever else that these different entities would like to have their compensation be when they're negotiating against you at the end of the day, right? And all of these, wonderful ladies and gentlemen, could potentially provide a lot of value to your and your kid's career, but at the end of the day, you begin the relationship by negotiating against them, and then they come on your side to negotiate for you in different relationships. So remember that before every single one of these individual kind of titles and functions, it's good to have an attorney to ensure that your terms with these folks are as proper as possible. At the end of the day, not all managers, agencies, or producers operate the same way, and they have different services they offer. And if there is a reasonable explanation for why somebody charges, booking fee and then, management fee and ancillary services and income fee, and they can reasonably explain the value that they're providing in the projects that they're tying that compensation to, then, for all intents and purposes, why not? But there are some instances where issues arise, whether it be to the compensation structure or exclusivity, the scope, the territory, your ability to terminate, your requirement to pay future commissions for work with the clients introduced by the manager after the term of the management agreement is done. So so-called sunset clauses of managers' continued commission after the termination of the agreement. And at the end of the day, parents should always understand whether the representative controls any approvals, can act as under power of attorney, whether they can control negotiations or speak on behalf of their client, meaning what is the scope of permissions that they're granted in their functionality, and whether they, what is the scope of their commissions? Are the post-term commissions reasonable? Because in some instances they are, like the example of the manager introducing the client and then you having continued relationships with that client. The manager logically needs to receive some form of a compensation through that, as opposed to less reasonable ones where, any and all affiliates or any money that you make because I made you in the space, those arguments kind of fall flat whenever, we are engaged in those negotiations. At the end of the day, these agreements shape long-term business relationships, not just single project. We got some social media clips conversations, right? So this is where it's important to monitor the scope of rights that you're granting any brands or audiovisual productions that you're working with. A child actor may appear in a show or a film, for instance, but that doesn't automatically mean that they can then repost clips of your child on TikTok or Instagram and get additional commercialization going from it, get additional ad revenue going from it. Studios often control reposting rights, promo rights, confidentiality obligations. And as a parent, you need to ensure that you don't violate any of the contracts by posting that BTS footage, by posting those social media clips, by posting trailers or screenshots. You want to ensure that you're complying with any confidentiality obligations, because otherwise your content may be taken down and your channel may even be taken down, because no producer or content production entity likes illegal use of their content, especially if it goes in contradiction with confidentiality clauses. So make sure to recognize those risks. Protecting your child's name. So one of the smartest long-term strategies is protecting your kid's brand early. And when it comes to protecting the brand, the actual legal mechanism through which that is done is usually a trademark, stage name, or domain name. That can also be something that you register a logo for, or a catchphrase. And why does it matter? Because as visibility grows, brand conflicts become more common, right? And impersonation becomes more common. So we regularly see fake social media accounts, fake domains and squatters trying to profit off of our clients. Unauthorized merchandise, counterfeit goods, third parties attempting to somehow capitalize on our clients' popularity. And early protection creates that leverage and it creates that instrument that you can use in the form of specific statutory damages prescribed for by the legislation when you perform a federal registration of a trademark. Those protections allow you to pretty comfortably exercise your, right to send people cease and desist letters and demand letters and claim the damages that are rightfully due to you, which is always a good form of compensation for any infringement that you're facing. So make sure to protect yourself early and file for federal trademarks. So what are some of the red flags that we see in producer agreements? So those can be perpetual rights, meaning that the producer can use the content forever. It can be all media now known or later devised, which attempts to cover technologies that not even exist yet. It may come in the form of not having a usage cap, meaning providing for unlimited exploitation without any additional compensation. It can also include pretty broad morality clauses, which can create subjective termination rights. And you can also ensure that you want to ensure you have some approval over the content, at least at some early stages. You need to know who controls the edits, who controls approvals, and whether you have any say regarding any forms of sensitive usage. And never assume that a contract is standard. Standard does not always mean fair. Standard might just mean what we had an attorney draft 5 years ago, asking them to make it as pro-producer as possible, and now we put this in front of everybody. Having an attorney on your side is of much assistance, specifically if you're being pressured into any type of deal. This is something where we always like to ensure that we protect our clients from, because no deadline is that serious that somebody doesn't have an ability or can't have an ability to review their contract and properly consent to the terms being put in front of them. So what are some of those kind of main points for you guys to consider whenever, if you're coming out of this presentation? I think I wanted to kind of put together a little bit of a checklist for you, and some of the stuff we've talked through is already discussed here. But to reiterate, I think it's always good, right? Repetition is, the mother of creation and whatnot. Do not rush into signing agreements. I think that is going to be a very important one. Just discussed it, right? Make sure to give yourself space and time to review everything carefully. Confirm the usage rights, the duration of the term, the exclusivity, the ownership. Understand labor law. That's going to be another one, right? Understand proper LLC and trust structures. Have them put together for your kid when they're starting out, so when they're 18, they can rely on existing structures to continue to generate capital for them instead of owning nothing and being left with nothing. Document all revenue streams, whether it be through the use of a bookkeeper or software or Rocket Money, whatever the case may be. You want to ensure that you have tracking involved and those business revenues separated from personal revenues, if any, to maintain limitation of liability. Don't forget about that one. And protect intellectual property, right? Whether it be copyright in the contents or trademarks associated with your kid's brand or channel name or any slogans or logos. The entertainment industry can create a bunch of wonderful opportunities, and I hope everybody has a chance to get the most out of the entertainment industry that they can possibly do. But in order to reach a certain level, in order to be successful, it's not something that a lawyer is gonna help you ever achieve. The only thing to get you to that success is your own determination and passion and talent and a whole lot of luck, as it always is required in these things. But what lawyers and legal structures and accountants and wealth managers and trust attorneys and tax, whoever else, can ensure that you have is that as high of a chance to not lose it as possible, since that structure and that legal protection is what preserves long-term value. Thank you kindly. I appreciate everybody for your time. I hope was able to provide some practical understanding of the legal and business side of the entertainment to the extent I was able to share as far as it relates to young actors and talent and creators. So if anybody has any questions afterwards regarding contracts or IP, creator businesses, YouTube channels, or anything of the above, feel free to reach out using the contact information on your screen. And thank you again for joining us today. I appreciate everybody's time.